So, Deputy Attorney General Edin Simbi Ababetuja for the first time after Chairman Wontumi conviction, Abusia and Sembebre and Ekoso our political highway. So, more fan na HS Nancy and Yina technical problems. A fee and a HSC resolve issue Nina every na Deputy Attorney General Nancy Moore a Chairman Wontumi ex council a friend of Andy Apiakubi Edin Simbi Abetuja all kase a day before such chairman Wontumi eba abeko court na chese yet a final ruling about bonten no chairman Wontumi friend no e ka kire say if say and go in favor of him abusua say any many me ya no omo go for appeal na deputy attorney general na nsema wo de betu ya no o say we chese chairman Wontumi ene lawyer Andy Apia could be end attaching a strategy and omofai into no dynamic assisi a Ghana phone nyina ehun say a strategic plan be no omofai. How come say o lawyer or say only case to be a wajai wesikwem afi ono mom na okwa friend say omon file for appeal na deputy attorney general say appeal by the appeal enye adwuma na enye adwuma china the deputy attorney general chairman Wontumi ne appeal okwa file no wa blocking no or say appeal na the appeal court na the omo bet enye possible say chairman Wontumi betumi akwa appeal yense mo bra mo yanko na yanko nkoti ensema course na ye ba ye de diaka ato am so unsubscribe ya subscribe na hit on the notification bell so na be any update be drop no wonsa ebetumi akabia ha gossip politics TV so madam ase.
I've heard that the counsel for former counsels had to describe him right now, but he told us that look, on the last day of the trial, Chairman Wontumi called me and he says, look, if this goes south, I want you to appeal for me. So you must have heard that they are planning to go on appeal on this.
I found it strange that actually happened. Oh. And it gives me a lot of, it supports our suspicion that swap of counsel which happened between the close of case and the judgment was only designed to delay the case, because you said you don't want this lawyer again. I want Attachian to come. Then after you have been convicted, before you go to court, you reportedly had told the lawyer that you didn't want that, oh, if I'm convicted, I want you to continue to represent me. It tells me that you clearly have a design, or you had a design to delay you just did that thing to delay the process. So that itself, I find it very strange. And when I heard it, I was like, okay, it's clear to Ghanaians that this whole thing is just a drama to frustrate the cause of justice.
In the state's view, is there anything to appeal?
We don't think there's any proper basis for anyone to appeal this decision. Of course, the right to appeal is guaranteed. You can appeal, but I do not think that any appeal will succeed against this case, as I understand it.
Consider regional chair. How does that come to you?
That cannot be an accurate description of what happened. I mean, this is a case which has been tried fairly, with a lot of the discretion during the trial exercised in favor of the accused person. So let me give you one example. The accused person filed his witness statement a piece, and when I say a piece, I mean he files. The rule is that you file all your witness statements, you disclose all your witness list, and file all your witness statements. Then we conduct what we call case management conference in respect of all the witness statements before we start calling the witnesses and then speaking. But what the strategy this accused person and his legal team did was they'll file one witness statement, and then we conduct case management conference on it. We finish cross-examining, then they file the next. That is what they did for all the witnesses that they called. In fact, in respect of one of the witnesses, they filed their witness statement. We did CMC on it. We started cross-examining the witness. Then they filed a supplementary witness statement. In the middle of cross-examination, they filed a new additional witness statement for the same witness. So the trial actually truncated And the judge, normally a judge should not even accept that kind of, but the judge accepted it and allowed us to have a case management conference for that supplementary witness statement for us to now start our cross-examination again. We all saw the manner in which they even ended the case. A lawyer tried the case, participated in the trial fully. A date has been given for him to file his address. A few days to the deadline for filing the address, they applied to court saying that the lawyer doesn't want to, the client doesn't want the lawyer to represent him again. He did not give any reason why the representation will not continue. He just said that he wants to exercise his right to counsel of his choice. And because of that, we also what happened, the trial, the judgment delayed, and the new lawyer had to be given additional time. Then this additional time expired just at the tail end of the judgment. They filed 2 processes asking the court to refer some matters to the Supreme Court and to postpone the judgment again. Thankfully, we opposed everything that they filed, and then the judgment was given yesterday. Now the question is, if this is a political persecution, and they believe strong, that means that you believe strongly that you are innocent, right? If you are innocent, the manner in which you even conducted yourself to the latter end is as if you knew that you didn't have a defense. And I don't know if you have had the opportunity to read the judgment, but most of the evidence that we have, the pieces of evidence that we have, which the judge relied on, came from their defense. Defense witnesses, the accused person's own comments, his own witness statement, his own police statement. Those were the materials that formed the basis for the conclusion of the judgment. So it will be shocking. It is shocking to me, but that they would say is political persecution. But I understand. What we do, this is politics in a way. I mean, what they are doing is politics. And they issued that statement, or they had a press conference when they had not seen the judgment. So do you expect them, now that they've seen the judgment, they will go back and say what we said was wrong? They would never do that. They would rather double down and say things. But so far, I don't think anyone has pointed to any aspect of the judgment that they believe strongly that is so erroneous.
What we have heard them say around the case itself, and perhaps you'd throw a bit more light on it when you say that the judgment relied on defense statements and the accused's own testimonies as well. Could that be the reason they say that from the get-go, the state didn't have a case against Chairman Wontumi?
No. You see, the fact that you relied on defense, the lawyers will say the best evidence is evidence which is from your adversary. If you accuse someone of stealing and the person comes to say, indeed, I stole, that is the best form of evidence. So that cannot be the basis for their saying that it's political persecution. It shows that they knew that they have done something, or they did something wrong, or they breached the law. And indeed, look, the law says 2 counts, okay? One is about allowing someone else to mine on a concession without the minister's approval. The other one is saying that you conducted some activities in a mining concession without, without also basically authorization, right? The only thing that the defense or the accused person has said in all this is that, first of all, he admitted that he indeed allowed the guy to go onto the concession. This is someone whom everyone knows is a Galamsey person. If you allow a Galamsey person, okay, to go onto your concession at a time when Galamsey was the major problem in that area, and his witnesses testified to that. His own witnesses, the former Western Regional Minister, admitted that the former Deputy Minister for Lands and Natural Resources, and Honorable Mrekuduka, they all said, look, Galamsey was the most important issue that threatened national security at the time.
But he said at the time he didn't know that was what, they were going to do on the land.
Yes, he said that is what that is.
And we are not going to retry the case.
No, no,
just,
no.
Just,
Yeah,
you know, to
at
put
all.
it into perspective.
Yeah, he said he has maintained one thing, that I sent a gentleman there to do reclamation. I did not ask him to do mining. Okay. The gentleman said, you and I knew from day one that I was going to do mining because it was reclamation. Why didn't you give me any money or anything to go and do the reclamation? The guy was going to plant coconut. So the guy drove from wherever he lives, be it Kumasi, he drove past all lands, all possible places of planting or investing into coconut plant, and decided that he will go to Samra Boy, okay, not to plant the coconut, but to reclaim the land first, plant coconut on it, and then how many years time coconut will grow for him to get profit. Even if that is business, does it make any practical sense that if you want to plant coconut, you didn't find any place in the whole of place that coconut will grow, but on a particular Galamsey site? You know, when you put all this together, I don't think you need even an adult to come to this conclusion that the story doesn't add up. But that is beside the point. A judgment has been given. We know as lawyers the way to, you know, if you believe that the judgment is wrong, you appeal or you do use other processes to correct it. That is not to say that they do not have the right to say what they are saying. They have the right to say they don't believe that the judgment was fair. They have the right to say it is political persecution. They have the right to say the accused, the prisoner is now a prisoner of politics or political prisoner. That is within their right. But as to whether it is correct, I think that's what we are discussing. And I hold a view that there is no basis for those conclusions that they are reaching.
And this person in question we are talking about, in regards to the coconut farm story, is the accused person turned prosecution witness.
Yeah, is a prosecution witness.
Okay. Could the state have done this case without those two who now became prosecution witness?
Yeah, we could. Just that it becomes easier to do it when you are having someone who is involved in the matter. Before we even, when the police arrested these guys, they had prepared a docket and they brought everything to us, and we saw merit in the docket before we took the decision to convict them. But you see, there is a policy behind the fight, the NDC's fight against Galamsey. The policy is that yes, those on the ground in the Galamsey are breaching the law, but they couldn't be there and they couldn't successfully do what they are doing without some big, rich, influential, as they call them, kingpins behind it. So you'll be wasting your time clearing the guys who are on the grounds at any particular time, because when you clear them, new ones will come, because it's a very lucrative business for them. So new ones will come. So why won't you go to the source? So that is the policy within which the policy, you know, statement that we were making.
I understand that, but the charge against Wontumi was not that he was engaged in illegal mining.
In this
facilitated.
Yeah.
In this particular
case, there are two
other
Galamsey cases.
Yes.
There's one on the Nimri Forest where he is involved. That the allegation is that he's involved in it. This is a different one. And where
he's facilitating. That's what the charge is.
Yes. Let me tell you something. From our investigations, okay, it is, and a lot of the agencies didn't discover this early, but that was the business model. It was an established business model. You go for the concession, you use your political or whatever connection, or whether you are qualified legitimately or not, you get a concession. Then, and his was a large scale mining. It wasn't a small scale mining license, that what we call lease that he had. It was for large scale mining, and that requires a lot of capital. So you go for this license, and then because you don't have the capital and you still want to make profit, the easiest way is to now open the concession up to illegal Galamsey miners to move in, and then you take rent from them. That is the business model. So I have heard a lot of people, just like you said, that he was more charged for personally engaging in legal mining. It's even a better business model if you look at the economics of it. And those involved in it know. So the big campaigns of Galamsey, they do not, some of them don't even know, they've never stepped, like Wontumi, they've never stepped on the Galamsey soil itself for themselves. But they get it and they allow the boys to go and do it, and they collect rent. That is the business model. So let's not seek to diminish the point that he wasn't charged for doing Galamsey, but for facilitating. In fact, the facilitation is where the big guys come in.
Okay, I understand that, but the subject of it being the business model was not a point of focus in court, was it?
No, I mean, the court is not interested in business models.
I agree.
The court is only interested in, have you done something which breached the law? So the court is not going to listen to different business
I understand,
models.
because I was going somewhere with that question.
Okay.
When I asked, the person who had now become prosecution witness was the one actually engaged in the illegal mining.
Yeah, they were the artisans. Let me put it that way.
Okay. So then I'm trying to weigh the two. That in that, this person will now get away with what they have done because they became prosecution witness.
If you say get away, that is not accurate.
Are you taking steps against them as well?
We entered what we call a non-prosecution agreement with them, and they have obligations.
Okay.
They have forfeited their excavators, their gold, everything that they had. We have taken them from them. So it's not as if we just call you, come and testify and go away. No. When we call you, every excavator involved in this, and they are running into, I think, about 70 or so excavators, gold, or metals suspected to be gold, monies, weapons, all those things have been confiscated, and some of them forfeited. So the impression should not be that we just call them, well, you come and tell us something and go. No, that is not what happened.
I don't think so. But then you can understand why people would, particularly people of the opposition, will now start to draw the two pictures together and then say, look, the person who was actually involved in the illegal mining became prosecution witness, and then they went after the facilitator. In your explanation, you say, look, that is the business model that people follow. So you're going after the kingpins. But it does not leave that out of the equation, that the actual person who was the artisan on the ground is not serving jail term.
I don't think you're addressing the issues, or you have paid attention to what I've said. This is what I'm saying, that there's a business model which is designed to avoid liability. So you put all your money into the Galamsey, but you have no actual physical contact with the process of actually digging the ground and pulling away resources and polluting water. But it is your company, it is your money, it is your resources that is funding that. It is your and it is not even correct to think that the fact that you are not the one digging and getting dirty means that you are not part of the Galamsey. It's a whole chain of production, from financing to forming companies.
So I'm just saying,
I get it.
The strategy.
If I may, I don't know why it is less of, or you are making it look like it's less of an offense to sponsor than to actually be.
No, what I'm asking is why we couldn't get all two together. Because you tell me, look, we still had a case, even without turning the accused persons into prosecution witness. So if we could get that, those two accused persons still get Sherman Wontumi.
They are actually not.
Why did we go for the easy route?
They're actually not true.
Okay.
They were around 30.
Right.
Some of them have already been convicted. So it's not just that we didn't go. I don't know if you read the case, you would see that there were about 28 other people who were arrested together with Jedu. Jedu is just one person that we have used to testify. The other 28 also are facing trial. So it's not as if you just said, go away and let's get. No, they are more than Jedu. Jedu is just one person. And Okum himself was also not involved in the Galamsey. He was a businessman himself, but a middleman between the big guys and the artisans.
Okay. So in terms of this strategy, right, was the outcome worse the strategy you chose to use? Was the outcome we got in the Chairman Wontumi case worse the strategy?
No, Brenda. I thought it was obvious that it's better than. The outcome far outweighs the strategy, the cost of the strategy. I don't think it's even an issue. the outcome of this strategy is several times worth more than the cost of the strategy. I mean, what's the point in putting Jedu in jail and spending a longer time having to try Wontumi, when you can let Jedu go, confiscate his excavators, his gold, and get Wontumi on top? That's what I'm saying. Like, you don't even have to think about it. It's just the obvious thing to do.
So Wontumi was the target?
No, it's not as if it's the target. If you say it's the target, as if he was sitting somewhere and nothing was happening and went for him.
Well, but if you're going for it after a kingpin, as you described him, then he will be your target. There's nothing wrong with that.
No, going for a kingpin doesn't mean that the kingpin is the target. And all the opportunities that were open to Jedu to plea bargain were also open to Wontumi. And he took advantage of the plea bargain. So it's not as if we said Wontumi cannot do plea bargain, Jedu come and do plea bargain, let's get Wontumi. No. Plea bargain law is available for everyone. And as you can see, he has chosen where to plea bargain.
Absolutely.
So he could have chosen this one to plea bargain. And even the one ongoing to plea bargain. So Jedu decided that I'm going to plea bargain, and he got his bargain and his reward or whatever it is. And Okum did the same thing. Wontumi said he was not going to. So it's not as if, it's not a question of target. If he wasn't involved, there's no way anybody would have got him into this case at all.
Right. Okay. I want us to talk about the accused person too, the second accused person, Kwame Inchi. There's been a lot of talk around who this person is. What can you tell us?
Yeah, so it's another way of cutting costs.
Okay.
At the time we were analyzing the docket, we suspected that this Kwame Inchi was not even a real human being, because we did our checks across the board. But we were looking at what is the cost of doing further investigation to conclude whether he was a real human being or not. And when he entered the box and we asked him, he couldn't provide sufficient information to show that this person actually exists. Because he was asked, I personally asked him, who is this person? And then he said, I think his answer was that he was his co-director. All attempt to get him to say other things. I think not everything went on the record, but I even remember in the courtroom, there was an issue where some other lawyers passed the judgment, is he your brother or something? But we believe, and this is not the first time, this is not the only person, even in the other one, the Exim Bank, there's another who we believe is his brother. But you see, when you are conducting investigation and trial, it's a question of cost benefit. You know, the man has told you that this person who is the second accused has never been part of the management of the company. He had left the country. In fact, the date he gave was 2021 and 2022. What we are trying the accused persons for happened from 2020, I think 2023 or 2024, 2025. So even if you go and establish that this is the person, apart from his role as a director, which he wasn't even effectively a director anyway, what else are you going to do by going further to look for him and spend money to get him? So we didn't focus on that, but clearly there was a lot of suspicion that this person may not be
real. Okay, so it means that in the cost-benefit analysis, you decided that, look, we won't spend resources on identifying who Kwame Inchi is because there is no lead.
Not that in resources identify, in finding him.
In finding him.
Yeah.
Okay. All right then. Let's look at some of the things that the NPP has raised.
And let me draw attention to something. See, this Wontumi case, the first witness was called on January 13th. By the end of May, we had concluded the case. We had concluded trial. Now, you need to, if you are using public resources as a prosecutor, you need to look at cost-benefit analysis. We wanted the maximum outcome with the minimum cost. So, and you don't want to spend all your resources looking for someone who will not add much to the case. So, a lot of economic analysis went into these cases. The selection of accused persons, the selection of witnesses, the number of witnesses to call. These are all, we had extensive economic analysis of this. So if you are going for this, it will cost us 10 cedis. But if you abandon him and do this other option, it will cost us 5 cedis. We have saved the country 5 more cedis and getting what the results faster. That was the analysis made. So it was easier for us to use the witness, the persons who would have been accused, as witnesses and save more time, save time, money, and effort by making them witnesses instead of following them, insisting that they are accused persons and then dragging this case for years and all that. So it's a whole different strategy, if you ask me.
Right. I want to look at the minority issues they have raised. They were concerned, and are still concerned, that Samuel Atachian, counsel for Chairman Wontumi, was not there on the final day of this case. They thought that that was wrong.
I think that is a huge misunderstanding of the law. If that is really their position, then they have really they have a great misapprehension of what the law says, and probably of what actually happened in court. Lawyer wrote a letter that I won't be available. At the time he said he won't be available, he has filed a motion and he has filed all the necessary processes that have to be filed. And then on the day, he sends his colleague lawyers from his firm to hold his brief. And the colleague lawyers came to court. So it wasn't as if Wontumi was sentenced in the absence of a lawyer. He had, I think there were about 4 lawyers for him from Atachian's firm. So unless you are saying that without lawyer Atachian, all the members in the firm are not proper lawyers to represent, but as far as we know, they are also lawyers. And there is no rule of law which says that unless the person who filed the motion comes to move it, the court cannot decide. Otherwise, imagine. No, let's look at the other side. If that were the rule, that only the lawyer who filed the motion or the lawyer is the only person who can get the case for it, it would be simple. I will commit a crime, I will hire a lawyer and tell the lawyer to travel anytime there will be a decision, and the court would have to wait for him. That is the other. So I don't think they understand this. What they are saying doesn't exhibit a serious understanding of the law, and or they don't understand what happened in court. One of the two is what that opinion or that conclusion is suffering from.
Was prosecution aware that Atachian had written about his absence?
We didn't receive the letter before we went to court, and I don't think we were even copied. But of course, we had responded to his issues that he raised in his address. We had filed our reply, and the motion he filed, we had made up our mind that we're going to oppose it on point of law because there was no factual disputes in his affidavit. Most of the things he said were things already on the record, and what he filed in the affidavit, in the motion, he had already raised that issue in the address, which we have responded to. So it was actually a surplusage filing another motion. But in any case, the law says that when you file a motion, even if you are not in court, if the lawyer is not in court to formally move the motion, the judge can look at affidavits, do the analysis, and decide what happens to the motion. So there's nothing illegal or anything fishy about that. I mean, anyone who has been practicing law knows this. It's not as if it's some high-level learning.
The chairman Wontumi get.
So abusua we ne ensema your course so our political highway so deputy attorney general and yet ten kase odesa ensem no tudwa e de amaya enye asem keto krabeda mase samoje pene kokotiza ensem we e de mai aha gossip politics TV. So Chairman Wontumi ye the latest update at Ebrem what is going on in a year in Sawan prison. You may be koso or abusua Chairman Wontumi na so ayeshi. Yabeda mase bio na ya jaimo hasi medamase.